On a single Friday in Washington, two federal judges handed the Trump administration two stinging legal defeats before the weekend. First, a judge temporarily blocked the Justice Department's so-called anti-weaponization fund, a $1.7 to $1.8 billion pot of money created from a Trump-IRS settlement, and ordered the president himself to respond to what the court called grievous allegations. Second, a federal judge ruled that the famed Kennedy Center for the Performing Arts had been illegally renamed after President Trump and ordered his name removed from the building. Two courts. Two rulings. And together they raise a question that cuts to the heart of the second Trump term: when a president uses federal institutions, federal funds, and federal buildings as personal tools, where does the law draw the line? In the next several minutes we will break down both rulings and explain why they matter far beyond the headlines. We will cover what the anti-weaponization fund actually is, where the money came from, and what the judge found so alarming, why renaming the Kennedy Center turned into a constitutional fight, what Senate Minority Leader Schumer and Senator Lindsey Graham said and why they could not disagree more, what the backlash means for the nomination of Trump's pick for U.S. Attorney General, and what CFR analysts say this judicial friction means for Republican prospects in the November midterms. Let us go to the timeline. At 7:28 p.m. on May 29, Axios reported breaking news: Trump was ordered to address what the court described as grievous allegations in an IRS-related case. Shortly after, Politico confirmed a judge had launched a formal inquiry into the Trump-IRS settlement that generated the anti-weaponization fund. By 2:36 a.m. on May 30, The Hill confirmed a judge had temporarily blocked the Department of Justice's $1.8 billion fund entirely. According to Reuters reporting, the controversy is also complicating Todd Blanche's bid for U.S. Attorney General, as backlash over the $1.776 billion fund is creating significant headwinds for his Senate confirmation. The fund was established through a settlement between the Trump administration and the IRS, with the stated purpose of compensating individuals who claimed the government had used tax enforcement as a political weapon against them. Critics, including Senate Minority Leader Schumer, described it as a slush fund, his characterization for what he called MAGA cronies. The second ruling landed earlier the same evening. AFP reported at 11:30 p.m. that a U.S. judge ruled the Kennedy Center for the Performing Arts had been illegally renamed after President Trump and ordered his name taken down. Axios confirmed, Trump's name must be removed from Kennedy Center, judge orders. BBC World amplified the story. Senator Schumer posted that the ruling was an important win, but the fight is far from over, pledging to keep fighting in courts and Congress. On the other side, Senator Lindsey Graham posted sharply, calling the Kennedy Center ruling a judicial power grab and expressing disbelief that a federal judge would deny the president the ability to manage renovations at the center. Graham added that he personally supports allowing Trump's name to be attached to the building, citing renovation work he described as more extensive than any president since the center's founding. Now let us put both rulings into a broader context, because together they form a pattern that legal analysts are calling significant. The question analysts are asking first is, what exactly makes the anti-weaponization fund legally problematic? The judicial concern, based on the Politico and Axios reporting, appears to center on whether the executive branch can unilaterally establish a compensation fund of this magnitude through a settlement agreement, effectively bypassing congressional appropriations authority. The grievous allegations language used by the court is particularly notable. Courts rarely deploy that phrase unless the underlying conduct alleged is severe. On the Kennedy Center, the legal argument accepted by the court appears to rest on the principle that federal cultural institutions established by statute can only be renamed through an act of Congress, not by executive order or board resolution. This may suggest a broader principle with implications for other federal properties proposed for presidential renaming since January 2025. A second question worth examining is the political downstream. According to CFR expert analysis posted by @CFR_org, Trump's sagging poll numbers and surging Democratic support suggest Republicans will likely pay a price in November over the Iran war, and the domestic judicial friction adds another liability layer. The analysis noted that Trump insists he is not on the clock when it comes to Iran, but he and his fellow Republicans are when it comes to the midterms. These twin court defeats, combined with ongoing legislative stalls on the reconciliation bill, paint a picture of an administration under pressure on multiple institutional fronts simultaneously. What makes the anti-weaponization fund legally vulnerable, and can the administration reconstitute it? Some legal scholars suggest the fund may possibly survive in a modified form if the administration can demonstrate congressional authorization or route compensation through an existing statutory framework. However, the grievous allegations framing suggests the court may have concerns beyond procedure, which could make swift reconstitution difficult.
Do these rulings signal a broader pattern of judicial resistance to executive power expansion in Trump's second term?
Some constitutional law analysts believe the pattern of rulings may suggest federal courts are increasingly willing to impose separation of powers limits on executive unilateralism in this term. Others argue each case turns on specific facts and that extrapolating a general trend is premature at this stage.
In Washington, D.C., both rulings land with immediate practical effect.
The Kennedy Center serves as the nation's premier performing arts venue, and its operational and naming status now faces legal uncertainty affecting planned renovations the administration had cited as justification for the changes. For the broader American legal community and civil society, the anti-weaponization fund ruling carries perhaps greater long-term significance. Across the country, individuals who may have filed claims under the fund now face uncertainty about whether compensation will materialize. For Senate Republicans, particularly those facing re-election in competitive states, the dual judicial defeats arrive at an uncomfortable moment. Senator Graham's reaction from South Carolina reflects the defensive posture many Republican incumbents occupy, forced to choose between defending executive prerogatives and acknowledging judicial limits. For Democrats in swing districts, the rulings provide fresh ammunition heading into what CFR analysis describes as an increasingly favorable midterm environment. Senators Warren, Schumer, and Booker have all been active on related institutional accountability issues this week, creating a coordinated narrative arc the party appears to be deliberately amplifying. And for the legal profession and federal judiciary writ large, these rulings add to an already dense docket of executive-judicial conflicts and raise real questions about institutional capacity to manage what some legal observers describe as an unprecedented volume of constitutional disputes concentrated in a single presidential term. Now, the strongest version of the administration's argument deserves a fair hearing. Senator Graham articulated it directly: the Kennedy Center has received more investment and renovation attention under the Trump administration than at any point since the center was founded. From that perspective, attaching the president's name to an institution he has actively championed is not vanity but recognition of genuine stewardship. On the anti-weaponization fund, the administration's defenders argue that the underlying premise is legitimate, that the IRS was in fact used as a political instrument in prior administrations, that real individuals suffered real harm, and that the settlement represented an attempt to make those individuals whole. Some legal commentators argue the court's intervention reflects judicial overreach into the executive's authority to settle its own cases.
As Graham framed it regarding the Kennedy Center, what a judicial power grab.
The conservative legal critique of this kind of judicial intervention is not frivolous. It draws on a long tradition of arguments about executive discretion and the limits of judicial review over intra-branch settlements. The Kennedy Center still has Donald Trump's name on the wall. The administration has not yet complied with the removal order. A federal court says it's illegal.
The White House hasn't moved. The next move belongs to the judges. Drop your take in the comments. Should federal courts have the power to block presidential fund settlements and building renamings, or has the judiciary overstepped? Tell us where you draw the line.